Good morning and welcome to our jurisprudence class. So this morning we will discuss sociological jurisprudence and its practical relevance to Ghana. So the point about sociological jurisprudence is to try and explore how some scholars hold the view that law is better understood by seeing law in action, by seeing how law actually plays out or manifests in society. So that is what we are going to be exploring. So sociological jurisprudence examines the interaction between law and how law is also shaped by social norms, behavior, and institutions. So as I indicated, uh, sociological jurisprudence insists that law should not be studied in just abstracts. That is, law should be studied, law should be observed in terms of how it actually operates in society. So, for example, if you look at the cousin whose work I've shared with you already, he will make the point that law should be seen primarily as a social institution. So law is a social institution that must be understood in the context of its actual operation within society. So if you want to understand law, look at how it works out in society. Don't look at law in a vacuum, in abstracts or in abstraction. Law should be seen in a concrete reality. And that concrete reality is how it interacts or plays out in society. So the basic premise or presupposition of the sociological jurisprudence is that law both influences and is influenced by social realities, including prevailing customs, power structures, and cultural values. So therefore, there is that, if you like, forward linkage and backward linkage, or there's that kind of symbiosis. Law is influenced by the realities in society. And the realities in societies include customs, culture, power structures. At the same time, law also conditions or shapes social realities. So how society is also as a result of the state of the law. And how law is also how society is. So therefore, sociological jurists explore not only law in the books, law in the legislation or statutes, the constitution, law in the case law, but also law in action. Because they recognize that law should be concerned about how official statutes, how legislation may differ from everyday social practices. It is one thing to have the law in the books, and another thing to see what is actually done on the ground. And that is the focus of sociological jurisprudence. And for that matter, by focusing on empirical realities, the actual happens. Sociological jurisprudence helps policymakers, judges, and lawyers craft laws that reflect real community needs and practices. And that is why later on, some sociological jurists will say that law is an instrument for social engineering. So that is, it is a tool or is a means by which you are able to shape society to a desired destination. So the question arises, why should we care about sociological jurisprudence? Why the sociological perspective matters in legal philosophy or jurisprudence? Well, it encourages a practical analysis of laws as it provides a useful light or illumination on whether legislative schemes genuinely work in real life settings. So that is important. So there are some scholars who take sociological jurisprudence or the law in action so serious because they actually go to the extent of conducting various surveys using social science methodology to try and collect information on how the law is working in society. There are a lot of laws which have been made, and on the statute books, I mean, they look great, but as to whether they are actually achieving the intended outcome or objective is another thing altogether. And that is why it is important to undertake or engage sociological jurisprudence. It is in ensuring that legal reforms remain responsive to ongoing economic, social, and technological developments. In other words, if we take sociological jurisprudence serious, when we are contemplating how to reform the law and let the law serve society better, we will not just sit on our desks and indulge in theoretical speculation or abstractions, but more importantly, we would like to use relevant tools and methodologies or techniques and try and find out how certain things are happening in society in relation to whatever law we want to reform, so that we have the necessary information to be able to craft the law in a way which will serve the desired purpose. So sociological perspective really matters because it balances theoretical insights with empirical observation. In that way, it promotes a legal system that resonates with daily social experience, so that we don't have like a disconnect between what happens every day in society and what the law actually espouses. So if we pay attention to the sociological perspective, we'll be able to bridge that gap. So we'd like to look at some of the important thinkers or proponents or contributors to what we call the School of Sociological Jurisprudence. One of such scholars is Rudolf von Jhering. Jhering propounded the idea that law is a social instrument. And by this, he meant that law should be understood as a dynamic means to balance social interests and achieve stability. And he would argue that rather than seeing law as a static set of rules, law should better be understood as mediating conflicts. For example, the tension between labor and capital, or tension between individual and collective interests. So law should be seen as a dynamic means of mediating such conflicts. Certainly, when it comes to industry or the world of work, the capital owners, those who own the businesses or who have invested in it, their interests do not necessarily align with workers who are providing their service or their employment. Workers would like to make more wages or salary, would like to get more paid holidays, would like to get a lot of a good working environment, and so many other things. Those who have provided capital, or just like you are students of company law tools, you can also use that as an illustration. Like shareholders and other creditors, they are interested in the company making more profits so that they will get good returns on their investment. And if you want to make good profits, you definitely need to cut down costs. And wages and other emoluments which you pay to workers certainly are part of cost. So if you seek to grow your profit, you definitely need to cut costs. So already there's a tension between the interests of labor and that of a capital. In the same vein, when it comes to the larger society, collective interest is in sharp contrast to individual interest. There's a tension between what the individual sees as serving his or her interests and what the aggregate, all of us together, see as serving our well-being. I'll give you illustration. For example, there are some individuals, or an individual would like to probably go and air or do live social media streaming and say a lot of things which will insult, right, other people, and that makes him or her happy. But then, collectively too, we are also interested in ensuring that you don't destroy reputation of individuals or group of people. So we have a law to check that, and there's a tension between the freedom of, let's say, the expression of the individual and how society accepts as acceptable boundaries. Not only that, when it comes to compulsory acquisition, let's suppose that you have a well-treasured property, but society says, collectively, that location is needed for doing something for the entire community. So the doctrine of eminent domain, compulsory acquisition, as we have, for example, under Article 20 of the Constitution, is triggered. And the property that you as an individual, you cherish so much, is going to go out of your hand. So you see that kind of tension. And you as an individual, you may probably not even be excited by the fact that prompt, adequate, and effective compensation is going to be paid to you as envisaged under Article 20. So Jhering makes the point that law should be seen as mediating some of these conflicts with the view to achieve or maintain social order. So therefore, he has instrumental view of law, instrumental view, or what you call the functionalist view. That is what law can be used to achieve, or what law does. So Jhering's emphasis on how law can shape social life remains relevant today. For example, when it comes to privacy laws and consumer protections, they often evolve in direct response to changing societal needs and market pressures. So, for example, privacy laws, including, let's say our social media communication like the WhatsApp and the rest. We have, for example, been made to believe that it's encrypted, meaning that it's only the parties to that chat and those permitted to see it, that will see it. But then, in the interest of national security, checking criminality, the state may want to still intervene and interfere with that. So now, despite the claim by Meta or those who own the platform that is encrypted, there are means which can override that encryption, and especially by the national security and then the National Communication Authority. So these are some of the things. And again, when it comes to consumer protection, for example, let's take a food, right? Food and drugs. We have the Food and Drugs Authority. Those who manufacture beverages, right? Alcoholic beverages or other kind of food would like to make more profits. But then there are certain ingredients or components which they use that may be detrimental to the health of consumers. So how do you actually regulate that? And that is also one of the ways in which the law will have to actually be used in a manner which respond to changing societal needs and market pressures. Another proponent is Eugen Ehrlich. Eugen Ehrlich advanced what we call the concept of living law. Okay. By the concept of living law, Ehrlich meant that we have the unwritten customs, the unwritten norms, and shared understanding that govern everyday behavior more effectively than formal codes might. In other words, Ehrlich reminds us that we should not just look at law in terms of what is contained in the statute, what is contained in the code, but we should be interested in what he calls like the living law. And that is why he attempts to explain that by the living law, he means that aspect of the law which is unwritten, the shared understandings or custom which govern everyday behavior. And if we look at our society, of course, thankfully, our constitution, even Article 11, recognizes the customary law. And if you look at how customary law is actually defined in Article 11 of the Constitution, Clause 3, that customary law means the rules of law, which by custom are applicable to particular communities. So by custom. applicable. So how the people themselves, how they understand things over time and how certain things are done. There are a lot of those things out there which are not actually reduced into any statute. So in terms of Eugen Ehrlich living law, we could see its practical relevance by looking at maybe like things when it comes to online or cyberspace, okay? We have community self-regulation. For example, those on YouTube, those on Facebook, Instagram, Telegram, TikTok, they have their own behavioral regulation. If you take Facebook, for example, they have their own ethics board. And that was why some time ago, they were able to block account of now the President of the United States of America. It was just their own community self-regulation board. In the same vein, as I indicated, we come to our local communities. We have our various customary practices. In Ghana, you move from one community to another. You will notice that there are certain practices which are known by those within that locality. And they are very much respected because that's how the people live their life by. And so that is the living law that Eugen Ehrlich is talking about. And of course, if you follow the claims of Eugen Ehrlich to its logical conclusion, it will help us to understand why informal norms sometimes override formal laws in guarding actual conduct. And it is true. Especially those of you, this Presbyterian University Kumasi campus, you're in Kumasi, so this point will come very clear to you. You take Kumasi, for example, the Ashanti region, let's say the Asantehene, and then the influence that he carries. I'll give you a typical example. There are times that he will make pronouncement that maybe nobody is going to the market or going to the store at the doom, or people should be in their house maybe by 7, and no one should go out because the palace is going to do certain things. And by and large, people comply. And this is not a law made by Parliament. This is not any case law or precedent, but people comply. Despite the fact that the Constitution has guaranteed various rights and freedoms to them, which may even override what men shall be saying. And yet, that informal norm, so to speak, will be adhered to, and that will override the formal laws, particularly how people conduct themselves. So that is the living law Eugen Ehrlich is reminding us of. Then we also have Émile Durkheim. I've already shared the cousin's lecture with you, so I expect that you go and read the chapter 15 and then chapter 16 as part of the presentation or discussion we are doing. That is why I'm using a broad brush approach and going very fast. But we are behind time. We need to move very fast. Émile Durkheim also view law as reflecting the prevailing form of social solidarity in a community. That there's a, when you say like the solidarity, it's like we mutually depend and support one another. As the founders will say, onsom, onyinipa or something like that, isn't it? So we support or depend or rely on one another. So that is social solidarity. So in Émile Durkheim view, law should be understood as being a reflection of the form of social solidarity which exists in a community. So he would identify what we call traditional or mechanical solidarity. You identify complex organic solidarity and made the point that traditional solidarity often yield stricter punitive measures, whereas a more complex organic solidarity fosters restitutive and cooperative rules. And of course, that also reinforces the view that it is the particular type of social solidarity pertaining in the society which the law reflects. I think that is the point Durkheim is making. So let us keep that in mind. Then he also identifies what we call the social indicator. So Durkheim contends that if you look at advanced societies as opposed to like a simple or primitive society, the legal arrangements in advanced societies is based mainly on contractual deals, that is in contracts. So contracts or consensual arrangement is the basis of legal arrangements in more advanced societies. And in those societies, interdependence demands more nuanced dispute resolution and regulatory measures. So let's look at it like modern societies. Certainly, these are the advanced societies talking about. Most of the things that we have are purely contractual, based upon agreement. Whether you are talking about the financial institution, you are talking about the general markets, just name it. Most of the interactions which we have in advanced societies are largely based upon contract or contracting. And for that matter, when disputes arise, there's the need to have a well-structured, acceptable, predictable mechanism of resolving them. And of course, and that is why we have like a whole elaborate, civil procedure justice, system or civil procedure rules. And now we even have a alternative dispute resolution mechanism, arbitration, mediation, conciliation, and so on. We also have another contributor to sociological jurisprudence, Max Weber. Those of you who have done the sociology before, you have encountered Max Weber and his famous classification of authority into traditional, charismatic, and legal rational categories. So if you look at the reality of modern legal system, you'll notice that we have heavy bureaucratic processes. And these bureaucratic processes have a certain inherent merit or advantage, including the fact that they are premised on codified norms and ensure predictability. So if you read Max Weber's work and you look at like the details of his classification, that which he calls the legal rational authority, it is that which actually explains our modern administrative, if you like, law and then various bureaucratic arrangements. And that is why, if you look at Article 23 of our Constitution, there's this provision on administrative justice. If you remember your constitutional law, so Article 23, for example, says, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law, and persons aggrieved by exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. So, administrative justice is premised on the fact that we have, well-structured, bureaucracies, and when those who occupy those, when they're exercising the authority, they should do it in a way to ensure fairness and justice. And that is why in Article 296, right? Article 296 of the Constitution, the framers of the Constitution provided the mechanism for checking the exercise of discretionary power. And that is why 296 will say that where in this Constitution or any other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of discretionary power shall not be arbitrarily, capricious, or based, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process. And C, where the personal authority is not a judge or other judicial officer, there shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of the discretionary power. So, Max Weber makes the point that law attains legitimacy through consistent application and impersonal rules. So impersonal rules underline, and that is why Article 296 is even saying that if you are be given discretionary power, you are supposed to come out with what you call like predetermined rules. Predetermined rules. Remember the case of Early and others against the Attorney General. Then the case of the Frances Ransford, and then the old case of the Kaftan versus the Attorney General. or emphasize how important it is to have predetermined rules or guidelines to let people who are going to be affected by the exercise of your discretionary power as to what they should expect and how you go about it. And that is why Max Weber is also making the point that, well, law becomes legitimate when there is consistent application. And the law is made up of impersonal rules. The law is not about a particular person. And of course, this is a good illustration of how modern democracies rest upon constitutions and various enactments or statutes, and also standardized judicial procedures. So those are the things which give legitimacy to the law. We also have Roscoe Pound, and Roscoe Pound's view is well known to a lot of us before we even come to study sociological jurisprudence. The view that law is an instrument or is a tool for social engineering. So Roscoe Pound comes to the table of sociological jurisprudence and bring another perspective, which is that law should be seen as what engineers do, if you like. What is engineering? Engineers will use their technical knowledge in order to solve what? A problem. Mechanical engineers will use that to solve things relating to machines, automobiles, and so on. Civil engineers, they will use their technical knowledge to get various civil works done, including bridges, major structures, structures engineering. We have a lot of high-rise buildings and all that. They will need to do a lot of computation. How can we have 20 level or story building without it collapsing? How should you work out things, the weight and everything? Is it an earthquake-prone area? If it's an earthquake-prone area, what material would be more useful? Should there be a tremor or an earthquake? So they will leverage on their technical knowledge to try and provide responses to all this. So that is what engineers do. So in the same vein, Pound would say that sociological jurisprudence should be understood as using law to engineer desirable social outcomes. So you have desirable social outcomes you like to attain, you like to achieve, and you consciously mobilize law and deploy it or set it in motion in a way or manner which will help you to achieve those desirable social outcomes. So let us keep that in mind. So law should actively serve society by balancing interests and promoting the welfare of the community. Of course, we recognize that there are various conflicting interests in society, no doubt about that. And that is why Pound, as far as his view, the functional view of the law is concerned, will make the point that law is an attempt to actually reconcile, harmonize, or compromise overlapping or conflicting interests, either through securing them directly and immediately, or through securing certain individual interests, so as to give effect to the greatest number of interests, or to the interests that weigh most in our civilization, with the least sacrifice of other interests. So, necessarily, Pound recognized that due to the conflicting or the competing interests, we need to strike a balance. In striking the balance, lawmakers and judges must try and achieve a harmony. And how is this harmony to be achieved? They should go after solutions which will serve a greater majority. At the same time, causing least injury or harm. That is to say that if it is possible to have an outcome which advances the interest of the majority and at the same time causes least insignificant injury to the minority, then go for that. So that way you achieve harmony between the competing claims. So you try to achieve like a fairness in trying to strike the balance. So if you take your law of tort, for example, if you remember the case law in tort, when it comes to, let's take the example, let's say that the rescue type of cases, or let's say ambulance, okay? If ambulance should, for example, run into someone and cause an injury or damage, and you are trying to determine liability, quantum of damages, should we deal with it in the same way as any other car or vehicle if involved in such situation we dealt with? A society not interested in having a robust around-the-clock response mechanism such as ambulance that can rush to where help is needed so that lives are saved. So if that is the case and something should go wrong in the course of that enterprise, should society not lower the bar and try to be more lenient towards the ambulance rather than how it will have dealt with other normal vehicles or other cars or road users? So those are some of the things. And this attempt to balance competing interests inform, feels like environmental law. Environmental law is one area where we have competing or contested interests. We like to have serene, healthy, green environment. At the same time, we like to exploit the environment for whatever wealth or resources embedded therein so as to alleviate poverty and create good life. Let's take the typical example of Galamsey, right? Of course, Galamsey is probably pejorative in our part of the world, but just thinking of exploitation of minerals, right, from our forests. You want to mine, but mining is going to destroy the vegetation cover. It's going to drive the animals which are in their natural habitat from there. And the chemicals which are used in mining may release certain poisonous substance into the system, so much so that it will be hazardous to people in the short term or medium or long term. But the minerals there are also quite rich. And if you tap or exploit them, you are going to turn so many poverties into prosperity. So what do? We see like the tension. But that's the kind of thing we are talking about. Especially with the environmental law, there's something called the EIA, Environmental Impact Assessment. If you want to do any development in any area, you have to contact the Environmental Protection Authority and go through the environmental impact assessment for us to try and estimate or assess the likely environmental injury you are going to cause by the proposed projects. And you'll be made to suggest countermeasures which will ameliorate those potential hazards. And if same are found satisfactory, then you'll be given the environmental permit and you're able to go on. On the other hand, if they are not found satisfactory, you'll not be given the environmental permit. Yeah, so I think that from our discussions so far, it is undoubted that sociological jurisprudence is useful in our modern day jurisprudence, how law actually operates in society. And typically, when it comes to legal reform, there's no doubt that the teachings of sociological jurisprudence provide useful insights. One, with respect to social justice concerns, if we have laws that have been made to address discrimination, it is because there has been some sociological research to ensure that such laws will actually resonate or reflect actual societal values. So let's take Article 17 of our Constitution, for example. Okay, Article 17 of our Constitution talk about is about anti-discrimination, and I think not too long ago too, we have also had what you call like the affirmative action the legislation in Ghana, and then passed not too long ago. Let's see if I get that for you. Yeah, I think the Affirmative Action Act 2024. It's, for example, a good example. I mean, it's a good illustration of the point that we are trying to make regarding the importance or the relevance of the sociological jurisprudence when it comes to law reform. Because you notice that legislation actually seeks to achieve gender equity. It seeks to achieve gender equity. So let's look at section 1, for example. Let's try to get my legislation for you. If someone has opened it, somebody should read the object clause, the long title and the object. Okay. So an act to provide for affirmative action for gender equality in public and private sectors and for related purposes. So if you look at section 1 of the Affirmative Action Gender Equality Act 2024, there is a provision to the further quote. The object of this act is to ensure the achievement of gender equality in the political, social, economic, educational, and cultural spheres of the society. Then goes on, implementation of this act and achievement of the target shall be progressive and subject to evaluation in accordance with the first schedule. So if you read the provision further, and if you read the background work leading to the passage of this affirmative action legislation, you will notice that there has been concern as far as gender equality or equity is concerned. And that is why this legislation was passed. And of course, it is sociological research which will have brought to the fore that, no, if we look at our country, we don't have fairness, we don't have equity when it comes to involvement of, let's say, women in our national life at various levels. Again, when it comes to family rights, especially spousal property rights, we see relevance of sociological jurisprudence. The same thing applies to labor protection. Now, when it comes to also public welfare, sociological insights will guide making legislation in areas like healthcare, technological regulation, environmental protection. And the point about sociological jurisprudence here is to ensure that the laws which are going to be made in these areas actually align with the community needs. Otherwise, you have what you call the top-down approach instead of bottom-up approach, if you like. Top-down approach in the sense that you just sit in your ivory tower or palace. You go to your drawing board, put big ideas there, reduce them into a bill, take them through the process in parliament, they become a law. When there has not been any attempt to conduct empirical studies into the particular problem that you want to legislate, so as to understand what really happens on the ground, so that if you are going to prefer some legislative antidote or panacea or solution, the solution you are going to suggest would actually be effective. Effective in the sense that it will attempt to respond to what really happens on the ground. But where you've not had the benefit of what happens on the ground, then you are just doing what lawyers will call an exercise in what? In futility. It will not achieve anything. It probably be a brutum fulmen, as it were. Give you a typical example. It's just like the same, the claim of sociological jurisprudence also aligns with some of the postulates of some development theories, right? That if you want to bring development to the people, go to the ground, find out from their lived experiences what actually they need. And then you try to provide development interventions which will respond to that. So that let's say that if the people need something like, let's suppose that you go to a community, right? They don't have something like, they don't have water, right? And go and build public toilet using the WC, water closet. You are just wasting resources. If you give them water first, before later you go to do that, it will be more useful, isn't it? And that explains how most of the things we've had in our country have not actually worked. Because oftentimes, politicians or technocrats will sit in the comfort of the offices in Accra and just think of what they are going to do in various parts of the country. Sometimes what we intend to do there may not be what is urgently needed by the people. But if you had gone into the community to observe, to ask questions and all that, you have had like a better insight into what is urgently needed by them with respect to their priority of needs. So that if you want to do anything, you target that. I think that by analogic reason, the same idea is applicable to sociological jurisprudence, mutatis mutandis. So you need to conduct the empirical research, find out what the true issues are, so that you let the law you are going to do respond to that. Again, as global and technological changes accelerate, law must adapt by engaging with real-world data and broad stakeholder consultations. And that is what sociological jurisprudence teaches. Now, you look at, I'll give you a typical example. In the US, I think during President Biden's term in office, I think getting to the latter part or so, there were threats to, or there were some executive orders to ban the use of TikTok in the US, okay? Of course, they had probably looked at it only from the angle of national security, that because the TikTok is, I think, is owned by Chinese firm or something, and knowing how the Chinese society is, how the Chinese government has control and access to everything in China, whether it's a public sector company or private sector company, it doesn't matter. The government of the United States, of course, legitimately was worried that that will make American vulnerable as far as security in that aspect is concerned. And that informs how there was that move to outlaw or ban TikTok. But then the fact also remains that most of the young people, the so-called Gen Z and all that, those are the places in the world where they operate. Those are the platforms you can get to them. And the last election, I'm told President Trump has recognized that it is necessary. Please, just a minute. Yeah, so President Trump has realized how useful TikTok was in getting the younger voters to be rich during their just ended political campaign and election. And that has also delayed the government going forward with a complete ban of TikTok in the US. So here, it's just reminding us of how finding out what really happens during stakeholder consultations will provide useful insights to inform policy and legal reform. So, how can law better adapt to societal changes? Well, for law to be responsive to societal changes, we need to have flexible legislative frameworks. And for that matter, there's a need for periodic review. There's no point to have legislation which are not reviewed to ensure that they are serving the needs, they are fit for purpose. And This mandate for regular legislative reevaluation to make the laws relevant may not be given only to particular institution, right? Maybe, of course, we have the Law Reform Commission, right? We have the Law Reform Commission in our country, but I had the privilege of working on the Law Reform Commission for 2 years, and I must say that it is not resource to be able to do any of these things we are talking about. But of course, it's not only the Law Reform Commission. Academics, those in law, those in other disciplines like sociology, economics, business, and so on and so forth, must also conduct research regarding certain laws in their relevant areas of interest to find out whether the laws are outdated, whether the laws are not fit for purpose, and for that matter, there's a need to review. So periodic review is very important to ensure that we can have a law adapting to societal changes. I'll give you a typical example when it comes to, let's say, litigation, right? There's what they call the service of process. If you see someone, the person must be served, the process must be served. So the purpose of service is for the person to be made aware that a process has been filed in the court against him or her, that he or she may also take the necessary steps. Now, when the rules that govern service were made, the world was different. The last 10 years have brought, even the last 20 years, have brought so many interesting things in the world in terms of how we communicate. Right now, almost everybody uses WhatsApp or some other social media of communication, emails, and so on. So if you have, let's say that your rules which govern service, which were made at the time that the society did not know anything called email, did not know anything called WhatsApp or Telegram or X or what do you call the Twitter, now X. But now all these things are here. If you are not doing research, you will not be able to revise the law to let it respond to what is actually going on in the world as far as how people communicate, as far as information reach people. And I give you another example. Still, of course, because I also work as a judge, my examples will coming from what I witnessed. When it comes to substituted service, for example, gone are the days when every day people were reading Daily Graphic or other newspapers which circulate in the country or in a particular region. Now, if you are to do research, you will notice that apart from few institutions where there's a subscription of these papers, and for that matter, they are just distributed, they are put there. Even people don't even read them because a lot of people, they get their news not from the print media, they get their news from electronic. Either they go to Ghana Web, City News, Manjo Online, Peace FM, or whatever, just name them, Asase, and so on. So therefore, if you are still working in a legal regime which says that, oh, if there's going to be statutory service, okay, one useful avenue is for a publication to be made in the Daily Graphic, then you ask yourself, is it really effective? When the reality today is that, unlike 10 years ago, many people don't read the newspapers. They get the same content from alternative means. Now, it is only empirical research which will expose some of these things so that it provides the justification for revision or recalibration of the law. Another way to ensure that we have flexible legislative framework is leveraging on pilot programs. And what do you mean by this? That is to say that we start with small-scale trials of any legal intervention. We try to pilot maybe a particular law you want to pass, maybe for the whole country or for the whole sector. We start on a smaller scale, right? And then we'll try and measure the real life impact before we do large-scale enactments. So you want to make, for example, a particular law. Instead of making a universal law for the whole society, in some cases, you may want to do it on a small scale and say, okay, this law, we are going to target this particular district. And then you can even put like a lifespan on that law. That maybe that law shall expire in 6 months or 1 year. And within that particular territory, and as the law is applied there, you have the necessary arrangement in terms of researchers, monitors, and observers trying to measure the real life impact of the workings of that law within that smaller community. So based upon what you say, if people responded well to that law, and for that matter, the intended outcome of that law is achieved, then that may provide the impetus for you to now enact it, let's say for the entire country, having already piloted it to know how it works. So that way, we can get the law to better adapt to societal changes. Of course, another way to do that is the public participation. So community engagement. We encourage input of local stakeholders and civil society in the legislative process. And that is important. Those of you who work with Parliament, you will notice that when a bill has gone through the process, it gets to a stage where referral is made to the relevant parliamentary committee. And then that committee will sometimes advertise in the papers or the media, inviting stakeholder input or the public to send their comments or concerns. Or sometimes they even hold like a forum, a public hearing, or they do a survey, either online or something. The point is, let the public make input. And once they make input, the law will reflect the changes which are taking place in society, rather than making a law which is out of step with what really is going on in society. Well, technological integration also can be leveraged to make the law better adapt to societal changes. In what ways? Maybe we can use things like data analytics, in which case uh, we'll be using various statistical trends to understand what is happening as far as the particular area of the law is concerned. And that will enable us to craft a more effective regulations. Digital platforms are also there, and that will give you a rare time public feedback on proposed reforms. So if we take the committee set up by His Excellency President Mahama to review the constitution, you will notice that they've also reached out to the public using the various platform for the public to make their input. We must also use interdisciplinary approaches. There's a need for sociological research. So social scientists, sociologists, social work experts, and other discipline experts must investigate how laws are actually experienced. And how laws are experienced will reveal the gap between law in books and law in action. I remember many years ago when I was still, I think I was either the third year of University of Ghana as a law student, and one of my professors, Professor Evio Dankwa, I think Professor Mensa Bonsu, they had like a project, and the project was trying to measure the impact of interstate succession law. So there were questionnaires which had been developed and were put in a car to Aburi. I remember we were few, like, I think we were just about 10 or 12. And we divided ourselves into, or we divided Aburi among ourselves. And we went to the various communities to try and administer the questionnaires. And the questions were actually trying to find out whether the people were aware of PNDC Law 111, whether anybody has ever died in their family, the person did not make a will, and then how did they go about the person's property and those things. So I remember this was, I think, way back in, I think, 1999. So that was done. And this is just an example. This can be done for any area of the law, okay? Any area of the law. You can do this research to find out whether the law as in the books is what is being complied with on the ground, or there is a gap between the law in the books and then the law in action. Of course, this interdisciplinary approach also calls for collaborative expertise. That is to say that to understand the workings of the law, you need to dwell upon economists, anthropologists, data scientists, sociologists, and many others to address multifaceted social challenges. I give you an example. I think there has been like a recent development. I think, if I'm not mistaken, I think that the Parliament has passed a bill abolishing, I think, is it a betting tax or something like that? Of course, so many other taxes, e-levy and all that have been abolished. And people are happy e-levy and the other taxes have been abolished. But just one tax which has generated some discussion, that is the betting tax. And we have like a divided schools of thought. Okay, the government says that I told the people of Ghana when I was campaigning that I will abolish it. To be an honest government, I have to deliver on what I told the electorate I was going to do. And that is exactly what I have done. As President Trump will say, when he announced the swooping second Nepal tariff imposition, President Trump said that promise made, promise was delivered. Just trying to tell them that, well, this is what I campaigned. I told you I was going to do. You voted for me. So impliedly, you've given me the mandate that I should do that. And that is exactly what I've done. So in a way, the government of Ghana also seems to be saying that, yes, we campaigned that we're going to abolish the betting tax. We've won decisively, and we need to keep our campaign promise. So that is exactly what we have done. The another school of thought is also that betting is problematic because the youth, it will embolden them to spend their times and energy and the little or few resources they have on betting. And with that matter, it's not good. We should rather disincentivize it. And you disincentivize it by saying that even if you win, the state is going to take substantial part of the win. And in a way, that will discourage you so that you come to the point and say that it's not worth it. Let me quit that behavior. So if maybe there has been some sociological or social research to find out how widespread is betting in our country, especially the demographic group, which age range of people participate in that. What are their motivations? Is it because of unemployment, or is it because of just the fun of it, or what is driving their appetite? So all those things could be ascertained, and then when you are armed with such a data, you now begin to find out whether it is worthwhile making it easier for people to continue to bet, or you need to make it more burdensome. You make it less and less attractive. Yeah, so those are some of the things. So to ensure that the law better adapt to societal changes, there's a need for education and what? Awareness. We need to incorporate sociological, economic, and technological training into law curricula. It's not enough for law students, future lawyers, judges, future law policymakers, and so on, to just be taught the black letter law, okay? So a lot of us, all that we know about law is when we make propositions, we cite provision from the Constitution or provision from a statute, or we cite case law. Then you are happy that you are learning law, you are learning real law. That is all that we know. But that is a very limited view of learning law, according to sociological jurisprudence, that it is important for law students to learn other disciplines, learn other economics, history, sociology, psychology, accounting, name it. And that other disciplines will help the future lawyer to understand the modern global realities. Public information campaign is also important in ensuring that law can better adapt to societal changes. In what ways? Where you make fine laws, okay, and people are not aware of the law, then what have you achieved? Yes, Article 1 says, Article 7 says that the law should be gazetted. You gazette it. That is just a formal publication. But the truth of the matter is that even those of us who are judges and lawyers, law students, how often do we go and look for the gazette? When was the last time you look at the gazette? So even those of us on the field, working with law, studying law, sleeping law, and eating law, if we don't even look at the gazette on regular basis, how much more do we expect the non-lawyer, the non-law student, the non-judge to know new laws which are made? It is therefore pertinent for public information campaign. And that is why we have the NCC, National Commission on Civic Education. But in my view, respectfully, we don't see much from them. Of course, they'll tell you that they don't have the resources. Ghana, the convenient way to provide justification for ineffectiveness in Ghana is to play the resource constraint card. As soon as you mention we are not resource, then you will now end the argument and you're able to get away with it. Now, if you look at the chapter 19 of our constitution, okay, you have the National Commission for Civic Education. And in terms of the functions of the NCC, if you look at Article 233 of the Constitution, the functions of the Commission shall be A, to create and sustain within the society the awareness of the principles and objectives of the Constitution as a fundamental law of the people of Ghana. B, educate and encourage the public to defend this Constitution at all times against all forms of abuse and violation. And then D, formulate, implement, and oversee programs intended to inculcate in the citizens of Ghana awareness of their civic responsibilities and appreciation of their rights and obligations as free people. And E, such other functions as Parliament may prescribe. Now, in terms of awareness of civic responsibilities, okay, what are the civic responsibilities? We have to go back to Article 41 of the Constitution. If we look at Article 41 of the Constitution, we are told that the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations. And accordingly, it shall be the duty of every citizen, A, to promote the prestige and good name of Ghana, and respect the symbols of the nation. B, uphold and defend this constitution and the law. Okay, that's where my emphasis is. To uphold and defend this constitution and the law. So that means that if you read Article 233 and Article 41 of the Constitution conjunctively, National Commission on Civic Education is supposed to undertake public information campaign to let the public understand the law, know the law. But as whether that is done is a different thing we can discuss. The judiciary should also be responsive in terms of letting the law adapt to societal changes. In what ways? When it comes to case law development. So courts should be encouraged to interpret statutes in ways that acknowledge current social context. And that will also depend upon the inputs that lawyers make. When it comes to interpretation of the law, for example, we now have the dominant interpretive approach, what you call the purposive approach of interpretation. And the purposive approach to interpretation, among other things, emphasizes the purpose of why the law was made. Why was the law made? What objectives the law supposed to achieve? Now, if we understand the background of the law, the problems which were identified or anticipated, for which reason the law was made by Parliament, if the need arises for interpretation to be done, if you're a lawyer and you very much appreciate this background, it will help you to invite the court to adopt an interpretive view which would actually acknowledge the current social context. And that is very important. If you go to some jurisdiction, there are some cases where lawyers will go to court with the necessary data, right? So as to enable them to put up a particular argument for the court to adopt, as it were. And again, when it comes to adjudication too, it is important for adjudication of various dispute resolution mechanism to be streamlined so as to ensure that disputes are resolved swiftly, or disputes are resolved in record time to ensure that it rapidly it meets the rapid evolving social landscape. And that is why it may be necessary to think outside the box. Society, things are changing very fast. There are certain types of disputes. You don't need to go through the traditional route. It may be necessary for mechanisms to be built which ensure that you can have certain judicial orders without having to go through the usual routine in court. How do we make use of technology? Yes, Edward, let's hear you.
Okay. Yes. Good morning, my lord.
Good morning.
Yes. In respect of the responsive judicial system, can we cite Martin Kpebu #2 versus Attorney General, which says or sought to state that all offenses are bailable. So, in that particular case, is sort of modernizing the law to suit the current society. So, in exam or in conversation, if you cite that case in respect of this, would the student be marked correct, or would the student be correct to do that? Hello, my lord. Hello, sir.
Yeah, sorry, I was making a call. Yeah, yes, what you said, the Constitution has already provided, this Constitution came into force 7 January 1993. So what Martin Pebble did was just to bring an old legislation, the Criminal Procedure Code or Act, which was passed in 1960, to conform to the dictates of our current Constitution. So that's what the people sought to do. That if you look at the constitutional provision regarding personal liberty, you cannot say that certain offenses you will not get bail, other offenses will get bail. But what I rather would like to see as an example is the practice direction which emanated from that lines of case law, which, for example, quite like when someone is arrested, the person cannot be detained for more than 48 hours. So let's suppose that someone has been arrested, this weekend. It will be possible for the police to, for example, get even a judge to make an order either on a phone or email as whether somebody can be detained, further remanded maybe for a few more days, or bail should be granted. Yes, so all those things are some of the offshot from the Pebble line of cases. Yeah, so you're right. And of course, let me also mention this. The making in terms of efficient dispute resolution as a way of ensuring that law adapt to societal changes, we can point to election dispute adjudication in Ghana, especially presidential election petition. If you look at the first presidential petition, that is a 2012, it took quite some time. I think it took over 6 months or something like that, if I'm not mistaken. And because of that, the judiciary learned lessons from that, and they came out with an improved version of election adjudication manual, in which the period has been shortened so much so that you don't need to even get up to 3 months or to conclude such a petition. So that is because they observe what the problem have been, and they said, okay, well, what can we do? Let's shorten certain timelines for following certain processes, and let's have a simplify the procedures, and that is it. Of course, in the same vein, uh, now we're having a class. We're about 50 plus in different locations, right? But through the mediation of the internet, we're able to communicate. And in the same vein, should people not be permitted to participate in dispute resolution proceedings, like court proceedings, without having to physically attend court? Is it possible for video conferencing facilities to be used for court proceedings? Of course, we have what we call the virtual court during the legal vacation. And during the legal vacation for the 2 months, August, September, the judges who sat in Accra, they did all their proceedings online. So the lawyers will be in their offices with their clients, and they can participate in the proceedings. Of course, as we have noted already, no school of jurisprudence is sacrosanct or flawless. So sociological jurisprudence has got downsides. And one of such downsides is that there's a potential for bias. Why is it so? There's heavy reliance on sociological data. And that is what sociological jurisprudence actually detects. And where we are going to rely heavily on sociological data, there is that risk that there may be subjectivity, okay? There may be subjectivity or polarized perspectives into legal decision. So that is the risk that we have. There's also objectivity concern. How do you balance empirical insights? That is the data you get from empirical inquiries with the desire for consistency. Rule-based adjudication can become challenging, isn't it? One of the things about rule of law is that there should be consistency, there should be predictability. But where you need to go outside the law in action, the law in the books, and to concentrate on the law in action, you are going to have problem of achieving consistency. So that is something that we need to also look at. Again, we also have practical constraints. And what are these? Societies are complex and diverse. If you take Ghanaian society, for example, it's a plural society, right? And the pluralism is quite manifest. Either ethnicity, tribes, language, religion, just name it. And for that matter, to formulate universal rules that accurately reflect every cultural subgroup may be difficult. So that is one of the things that we have to also think of. I'm going to give you a typical example. Let's suppose that the state is worried that maybe people spend a lot of time and money on funerals, okay? We are going to legislate and ensure that funerals, burials and funerals are held, let's say, within 2 weeks after the death of a person. So that is the law. Now, that law may not work for obvious reason. We have different cultural groupings, religious groupings. For our brother and sisters, Muslims, usually within 24 hours or maximum 48 hours or so, burial should be done. The people from the south, especially the Ashantis, they would like to gather resources and get all people who matter as far as the funeral is concerned to actually come home before it is done. And sometimes this may take 2 months, 1 month, 3 months, even sometimes a year or 2 years. So it's difficult to create general or universal rules on matters like that. There's also the risk of overreach. The sociological jurisprudence relies on social engineering. And social engineering means that you are consciously trying to achieve certain outcomes using the law as a tool or as an instrument. Now, that could intrude too deeply into private or community-based norms. Certain ways of doing things or looking at things or appreciating might have crystallized within the group over many centuries. But social engineering, just like typical, let's take something like the interstate succession law, okay? Interstate succession law is even like a good case study as far as social engineering is concerned. You know from your law of succession that prior to 1985, we have different regimes as far as inheritance was concerned, depending upon your personal law, your customary law, whether you're a patrilineal system or matrilineal system, and you know the implications. So if you're a patrilineal system, you know how the property devolved, and the matrilineal system. Now, we've mentioned the case of Enrique Kofi Antubam many times, and you, for example, made the point that in that case, we're told that if your father, for example, had the property and died, and you'll be allowed to live in the house only where you have good behavior. Just imagine that. And where you had used the support and services of your wife and children or your husband to build your life and develop, get properties and all that. And if you pass on, the very people that help you to have a meaningful life, okay, will not be allowed to benefit from those property if you didn't make insamanso or you didn't make a will or testamentary disposition or declaration. I mean, that is obviously unfair. And that was why PND's law 111 came in to say that if you don't make a will, we don't make samanso, then we are going to have a uniform approach in distributing property of a person who died intestate without making a will. So that is law being used as a tool for social engineering. If engineering in the sense that if you die intestate, it doesn't matter whether you're Muslim or you are Christian or you are Wale or you are Ewe or you are Ga or you are Santi or Dagate. We are all subject to uniform rules for greater part of the estate, about probably about 80% or 85%. It's probably about 10 or 15% in which your customary law or personal law may have some relevance. Well, the other challenge, as far as sociological jurisprudence is concerned, is that we have rapidly evolving data. Attitudes, technologies, and social conditions shift quickly. They are changing every now and again at a fast pace. And for that matter, if sociological jurisprudence insists that law should be informed by current data, now what is going to happen is that data will soon become outdated. And for that matter, it will necessitate or require frequent revisions because things are moving so fast. Attitudes are changing, technology is changing, social conditions are changing quickly. So if sociological jurisprudence says that, okay, the law should be based upon what actually happens in society, that you need to be doing a lot of revision every now and again, so much so that it may even become difficult for you to also make the public aware so as to align the actions with what the law says. So that is the other challenge. Now, there's one thing I want us to do. I want us to look at the Constitutional Revision Commission, which I had the privilege of being part of during President Mills' term in 2010. So in 2010, we had the Constitutional Review Commission, and the idea or the mandate was to comprehensively review the Constitution. So I want us to reflect on that. Of course, I'm aware that currently there's a new Constitutional Review Committee which has been set up by President Mills. I'm not talking about the current one. The reason being that usually when you're doing case studies, you do case study with things which have actually concluded, not things which are still evolving. So this one is still evolving in very early stages. So we're not using that one. We are using the 2010 Constitutional Review Commission as a case study. And if you look at the Constitutional Review, is a reflection of the call for review for the Constitution to address emerging social, economic, and political changes. No doubt, we had this Constitution enter into force 7 January 1993. Ever since then, so many aspects of it have been tested and challenged by things which happen in our society. Now, I was part of this, as I told you, and in terms of like the process, how we went about the work, okay, we sought to involve ordinary Ghanaians, civil society, traditional authorities, and other stakeholders. And I remember very well, I was the lead researcher for Ashanti region and to some extent Eastern region. So we went through all the districts, and every district we held public consultation, and we had what you call like an instrument, that is a survey instrument, which we were using to actually do the particular review to get the ideas or the views which we needed. So we had broader stakeholder engagement in public consultation and consultation, public hearings, and community feedback. So issues were actually broken down into, smaller ideas in a way which the ordinary public will understand. And I remember very well, I even still have some of the video recordings from that consultation still on my computer. So this was 2010, so you can imagine how many years, and that's about, is it 15 years? Yeah, that's about 15 years now. So why did we involve local groups and go to the extent of even having public hearing? Well, the purpose was to capture rare social experiences as far as the Constitution is concerned, so that if changes were going to be suggested, the changes would not solely be top-down imposition, but would instead reflect the living law, if you are using Eugen Ehrlich's terminology. So the living law, that is, that which govern the day-to-day lives of Ghanaians. And that was the point. For example, I remember this LGBT thing, right? What do you call it? The Tumut thing. It's not like a new thing. I remember we actually formulated an issue, and there are two schools of thought. One said that, okay, we should put it in a referendum for all of us to decide on it. Another school of thought said that, no, we should just leave it to be addressed by the court through judicial interpretation. So these things are not new. And again, when it comes to issues of national development, I remember a lot of people were concerned that whether political parties should be allowed to just propose anything in their manifesto, or you should have like a national development plan which would constrain political parties to craft their manifesto promises within the context of that. So all those things. And the report of the Constitutional Review Commission 2010, I think, is available online. You can just download it and then ascertain some of these things for yourself. Yeah, so if you look at it, the national outreach, the fact that all the regions, were involved. At that time, we had only 10 regions. We didn't have 16 regions. Various rural communities, various groups, various religious groups were all, involved in the consultation process. Actually, ties neatly to what sociological jurisprudence teaches. That is, a law gains legitimacy when it aligns with community social realities, rather than remaining an abstract reality. So people should come and say what their view or what their encounter with the Constitution has been. Is it good? Should it be retained? Should we make changes? Should we take something out? So those are some of the things. I mean, the process also recognized traditional institutions and customary norms, like chiefs and traditional councils, like the regional House of Chiefs, National House of Chiefs, and the various traditional authorities were very much involved. And the chiefs were engaged at their various level, and they were supposed to help us to understand whether there are aspects of customary norms or customary law which we needed to actually tweak or modify in order for it to advance our aspiration as a people through the medium of the Constitution. So by attempting to acknowledge the role, the contribution of traditional practices, traditional authorities. The Constitutional Review Commission and the work that we did attempted to harmonize official legal structures with grassroots social control. And that mirrors Ehrlich's concept of living law. And we are told that unwritten norms often have stronger social force than codified statutes. So if you go to your community, you go to the Awomafia of is it Anlo, or you go to Bugri Naba, you go to Yana, you go to the Santehne, you go to Osajefo, you go to, just name it, the chief, and you take their views. Anonymous, what do you think? And if you go to the Constitutional Review Commission report, it's surprising. The traditional authorities are of the view that we need to comprehensively overhaul our constitution, especially regarding decentralization, and give the chiefs a more prominent role in governance, especially at the grassroots level. And it is true. If you go to, I always use my people as an example. If you go to Ashanti region, right, Kumasi, for example, if you take the mayor of Kumasi and you take the Asantehene, I mean, without any disrespect, just for academic purpose, if the Asantehene, for example, speaks and then the mayor of Kumasi speaks, who would the people listen to? The people will listen to the Asantehene first before they listen to the mayor of Kumasi. Not because of the personality of the mayor of Kumasi, but because the Asantehene is what he is within the scheme of affairs within the Ashanti region or the Asante man. And that is why Nananum or the traditional authorities actually advocated that they should be given more room. They should be given more say as far as governance is concerned. Maybe it's something for us to actually ponder as we also we have the current constitutional review exercise going on. Then there's also a focus on the socioeconomic realities. If you look at the Constitutional Review Commission, what we did, a lot of the stakeholders pointed to development needs, economic inequalities, and concerns regarding resource allocation to shape constitutional amendments. So, I mean, if you look at the weight of the submissions, they gravitated more towards letting the constitution, become a tool for achieving or accelerating development. And no wonder Professor Atukuba, the current dean of the University of Ghana School of Law, he was our boss at the time. He was like the executive secretary to the commission, and for that matter, hired us to provide the research work. Later on, when he writes his book, The New Constitutional Administrative Law of Ghana, he will essentially be projecting how the constitution should be mobilized or should be deployed to accelerate development. And if you also look at the report of the Constitutional Review Commission, I think that was like the thematic direction. So how do we have a constitution that enable us to develop. So, in making suggestion that there should be amendments that would directly influence living standards, regional equity, and distribution of power. Also reflects Roscoe Pound's principle of social engineering, where law is used to solve concrete societal problems and not merely to declare lofty ideals. So identify problems and then consciously mobilize and deploy law to solve that. Yes, the work of the Constitution Review Commission, apart from the various fora that we did, and then the various, how to call it, the special stakeholder consultation, which we did at the smaller level, the commission also, did extra empirical work by trying to gather data on how Ghanaians perceive governance, national institution, and enforcement of constitutional provisions. It was during that work that we realized that if you are elected president of Ghana, in terms of maybe direct appointments, okay, you have about more than 5,000 appointments to make. And that gave us an idea of how powerful the position of the president is within the scheme of the 1992 Constitution, and people expressed concern that we need to rework that. And again, if you look at our current democratic experience, in my view, one of the greatest concern is what you call like the winner takes all. The winner takes all in the sense that if NPP, for example, should win, all the appointments and other things, they largely give it to their sympathizers. If NDC should win, they do likewise. And that explains why political changes for election is a big deal in the country. So people express concern that if there could be a way by which parties that are able to get some seats in parliament will get some either appointment or something like that, that will actually curb the unhealthy rivalry and competition to capture political power, which we have now because of the winner take all syndrome. So all these ideas came up from the empirical research which was done, and that actually reflects Max Weber's notion of rational legal authority. As we have noted, by rational legal authority, it makes the point that legitimacy of governance structures is boosted through demonstrable evidence of efficacy and public acceptance. So what do the public want? What are the ideas? If you realign the constitution, if you modify or you tweak the constitution to reflect what the public wants, then the law will be legitimate because there will be maybe what development experts will call like ownership. The law will be owned by the public, the people. They own it in the sense that they made input for it to be made to suit what they want. And again, the modus operandi, how the commission worked, the empirical data gathering analysis that they did, also reflected real-world outcomes consistent with what sociological jurisprudence actually teaches. So, reforms which were proposed made reference to the actual performance of institutions, the judiciary, legislature, local government bodies. Let's say the judiciary, for example. There's a concern as to how appointments are made into the judiciary. So, should we, for example, go to the American, some of the American states, where they actually have election to elect judges, or should we actually get an independent, like a public, maybe body like maybe Judicial Council or something like that, which would actually go through processes to hire people without involvement of the government of the day. So these are ideas which actually came up. Then if you tell like the legislature to like the same thing, there have been like concerns. This concern about people having dual citizenship, for example, not being eligible to run for the office of a member of parliament. Is this something that we want it to remain as part of our constitution? So these are some of the ideas which, for example, came up. And if we look at it, the proposed revisions, if you look at the Constitution Review Commission report, you'll notice that they are not proposal dropping from abstract or just dropping from the sky. They actually emanate or originate from the ground, from that which have gone on. So therefore, from the law in action, not just the law in what? In the books. And that reflects what Durkheim argued, that law should be understood as an external index of social needs and solidarity. Yeah, so because of time, we will draw the curtain down here on jurisprudence. And there's another, matter I wanted to discuss with you, but I think that you will look at it in the notes when I give it to you. But the second case study I wanted to look at is the Supreme Court decision on spousal property rights in Ghana. If you look at how Supreme Court has been rendering decision with respect to spousal property rights, do we see sociological jurisprudence as being evident, even if it's not explicitly articulated in those decisions? So those are the things that I wanted us to discuss. And as we have noted, the sociological jurisprudence postulates that legal rules must be understood and applied in light of the society in which they operate. So courts, legislators, and other legal actors are supposed to examine social realities, customs, and power structures to ensure that law reflects living societal conditions. So if you look at our Supreme Court treatment of spousal property rights, particularly, remember the famous mensa and mensa jurisprudence, where there has been recognition of non-monetary contribution within a marriage. For a long time, if we talk about property between spouses, we talk about contribution, and contribution here, we are talking about quantifiable contribution. But as a result of modernity and changes, our apex court has actually risen up to the realization that we need to deploy legal doctrines in a manner which will align with real life relationship and then the changing social norms. If you look at our society now, things have changed, and that should be factored into how we deal with rights of spouses when it comes to properties. So historically, the position of the law was that during divorce or separation, when we are talking about how property should be split, it depended on direct financial contribution. So if you were a spouse and you could not prove monetary investment, uh, then you will not get the share of the matrimonial property. And it did not matter if you contributed significantly through domestic maybe support or labor or childcare or supporting a spouse's career. So one will argue that that orientation mirrored black letter law approach, in which case there was little sensitivity to one, the realities of marriage in many Ghanaian households, where we have split of roles. One spouse's domestic contribution free the other to earn and accumulate assets. And it is true. I mean, uh, you are busy, maybe either the woman is busy working, so the man will have to help, or the man is busy working, the woman will have to help more, and so on. So those are the realities. Then it also had a little sensitivity to the socioeconomic conditions that often prevent one person, usually the wife, from having formal employment or direct financial input, even though that spouse's indirect contribution are vital to the family welfare and wealth creation. I mean, this is something I think all of us can relate to in one way or the other. But there has been a paradigm shift to recognize non-financial contribution. So there are a lot of cases which you are familiar with, but we just mentioned the case of Mensa and Mensa, where there was a groundbreaking jurisprudential position articulated that as far as domestic labor, childcare and management of the household cannot amount to valid contribution which deserve of an equitable share in property acquired during the marriage. And if you look at the Constitution, I think the Article 22, that also the property rights of spouse, if you look at Article 22, Parliament is supposed to make law which will regulate the property right of spouses, but that law has not been made yet. And that is why the Supreme Court ingeniously took advantage of the situation Mensa Mensa to come up with this particular position. So Mensa Mensa embraced the reality that non-monetary input often supports or enables the breadwinner's spouse's financial success. And in this way, the court acknowledged that property accrued is a product of joint effort and not just the effort of the one who made the direct financial contribution. Of course, a lot of cases have developed on the back of this, which you are familiar with. So, no doubt, this push out of the Supreme Court regarding as far as the property rights reflects or validates some of the claims of sociological jurisprudence. For example, Ehrlich tells of the living law that law must reflect on the ground realities rather than cling solely to codes of precedent, ignorant of social practices. So the precedents which had governed this particular area of the law was actually out of step with what happens on the ground. So by acknowledging indirect contribution, as we saw in Mensa and Mensa, the Supreme Court embraces the idea that law should incorporate rare household economics, isn't it? For example, cooking, cleaning, or child caring or rearing, rather than maintain an outdated assumption that only paid work counts as value. So if you are doing household chores, you are doing all the things which makes it worthwhile to live in a house decently, that should be reckoned or recognized as a contribution. So that approach by the Supreme Court could be said to have closed the gap between the law in the books and then the law in action, in the sense that it aligns legal outcomes with the lived experiences of married couples. That is what really happened. Again, if we also take Rudolf von Jhering's version of sociological jurisprudence, that law must mediate conflicting interests in society. We could say that if we look at the spousal property cases, one spouse's claim for an equitable share of property might conflict with the other spouse's claim to sole ownership based on direct financial outlays. Well, one would say that, but I took a loan and I had to work to be able to do this. So why do you want me to share this property with you? So you have that kind of like the conflicting with interest. But the other will say that, but I was also providing food, laying the bed, doing all the laundry and other things, taking care of the children. That is why you could also work to pay all the loans. So by balancing recognizing the intangible contribution, the Supreme Court balances these opposing interests, and for that matter, seeks to achieve social stability and fairness in marital property distribution. Again, if we want to also look at it from the point of view of Roscoe Pound, who view law as a tool of social engineering, we could say that the court is shaping Ghanaian society in significant ways by, one, incentivizing fairness. Its spouses know courts will acknowledge non-monetary efforts. It reduces exploitation or undervaluation of stay-at-home or lower earning spouses. So you know that because sometimes you see some couples, especially those who are not even aware of the state of the law, as if you have like competition regarding property. So people are making property as if they are in competition, forgetting that the law has developed up to a stage where even non-direct financial contribution will be recognized as a legitimate basis for you to be given a share in the property. It also encourages a stable family system, because this jurisprudence, Mensa jurisprudence, actually seeks to achieve equitable property distribution. In that case, it lessens the economic vulnerabilities that might otherwise dissuade the spouse from providing domestic services, as we can see. Again, if you want to look at it from the point of view of Durkheim, Durkheim makes the point that law is an external index of prevailing solidarity and moral consensus. So in that view, or in that way, we can say that what the Mensa law jurisprudence seeks to do is to actually legalize some of these shifts, which would value gender equality spousal collaboration, and mutual respect. So in that case, law guides and reinforces new social norms about marriage as a partnership of equals, unlike the past when wives were seen as second fiddle or as subservient. Is no longer the case. Wives and husbands are co-equals. Okay, so we will end it here. You read the rest because we need to switch to company law.